Afternoon from London, everybody. Welcome to our Professional Employer Organisations panel event, and thank you for taking the time to join us. My name is Miriam Lampert. I'm a partner in the Labour and Employment team in London at Squires, and I'm joined on this webinar today by two of my colleagues, Annabel Mace and Patrick Ford. Annabel, Patrick, can you just briefly introduce yourself?
Thank you, Miriam. I'm Annabel Mace. I'm also a partner in the Labour and Employment team with Miriam in London, and I head up the business immigration team.
Hi everyone, I'm Patrick. I'm a tax partner based in our Manchester office.
So I'm sure everyone on this webinar will know that over the past few years there's been a huge increase in remote working. This is a result of a number of factors. COVID was obviously a huge game changer, as vast numbers of employees were required to work at home, in many cases for the first time for extended periods of time. And I'm sure that many of you will have had employees who went abroad during COVID to be with family members. And I know that lots of our clients had to very quickly establish policies during COVID on overseas working to ensure that they weren't falling foul of overseas employment law, tax and immigration rules. And we certainly saw rapid developments accompanying that in terms of technology that is needed to support remote working. At the same time, certainly within the UK, employers have had to continually grapple with the war for talent, coming up with new and innovative ways of trying to attract and retain talent in a highly competitive market. And we're certainly seeing that employees who are not being permitted to work remotely, particularly domestically, are voting with their feet, either leaving to join competitors who are agreeing to be more flexible in work location, or simply turning down job offers or not applying at all to employers who are not seen as being sufficiently flexible. Assuming, of course, that job requirements don't make this impossible, certainly within the UK, the legal issues associated with allowing an employee to work in another location within the UK are not particularly complex. However, what we've seen, particularly since COVID, is an increasing demand for employees to be permitted to work in another country altogether. At the same time, in the global economy in which we operate, and given the challenges of finding the right talent locally, more and more businesses are looking for ways to engage talent from other markets around the world. And similarly, businesses are looking to expand into new markets, but often want to test the water without, for example, setting up a local subsidiary or having permanent hires before fully committing to the market. So even if you do manage to identify suitable talent overseas, there are then a whole range of challenges and risks associated with hiring those employees directly. Firstly, in many countries, the law provides that employees can only be employed by a local entity, and in many cases, employers don't have a local subsidiary. Whilst in some cases, setting up a subsidiary can be a relatively straightforward exercise, there will probably be ongoing compliance obligations, and in some countries, there may be a requirement to have a locally based director, which may rule out establishing a local entity altogether. And even in those countries where it is possible to employ someone through an overseas entity, such as in the UK, depending upon the work that the employee carries out, there's the risk that the employee's activities will create a permanent establishment from a corporate tax perspective, which would mean that the overseas entity could be subject to the local corporate tax regime and have a proportion of their corporate profits taxed locally. There's also then the issue of the fact that the employees need to be paid and taxed locally, so there needs to be a local payroll established. This all means that even if you're only hiring one employee in one country, it can be a very time-consuming and extremely costly exercise to get the employee up and running. And this is where professional employer organisations and employers of record come into play. Confusingly, the various providers of PEO and employer of record services don't have an entirely consistent approach to what constitutes a PEO and what constitutes an employer of record, and some of them use the term interchangeably, which isn't particularly helpful. Some of them refer to a PEO arrangement as being a kind of dual employment model where the end user client acts as a co-employer of the employee together with the PEO. And then they refer to an employer of record arrangement as one where the employer of record is the sole employer of the locally based employee. For the purposes of this talk, we're going to focus primarily on the employer of record sole employment model, because in our experience, that's the model that most people are using, certainly outside the US, given the challenges associated with being a co-employer. The basic model of an employer of record sole employment arrangement is, on the face of it, a fairly simple one. You identify talent in another country that you want to work for you, and the employer of record will act as the employee's sole legal employer in that country. The employer of record enters into a contract of employment with the employee and then effectively assigns the employee back to you as their end user client so that the employee carries out day-to-day duties for you. The employer of record then pays the employee and operates a local payroll, ensuring that all local payroll taxes, social security contributions and other required deductions are paid. So far, so simple, and on the face of it, a solution to many headaches. However, whilst there are undoubtedly a number of advantages to this model, particularly as a short-term stopgap measure if you want to get someone on board quickly, it's really important that you're aware that this is not a model that comes without legal or commercial risk. And what's particularly problematic with these risks is that they'll vary from country to country, which means that if you have a low risk tolerance threshold, you're going to need to get country-specific legal advice every time you engage talent through an employer of record in a new country in order to be clear on what exactly it is you're signing up to and the risks associated with it. And suffice to say, the cost for obtaining that legal advice will quickly mount up. So in this webinar, myself and my partners, Annabel and Patrick, are going to share our thoughts on some of the legal and commercial issues that you need to be aware of when considering whether to engage the services of a PEO or an employer of record. So Annabel, turning to you first, many employers of record make fairly broad promises that they're able to provide their services around the globe. However, it's my understanding that there may well be challenges in using this model in many parts of the world. So perhaps you can share your thoughts on that.
Thank you, Miriam. So I'm going to cover two areas which regularly overlap with employer of record arrangements. First, I'm going to talk about the immigration implications and then something called restricted labour leasing. So first off, with immigration, we regularly see immigration requirements being overlooked, mostly accidentally, to be fair, and particularly post-Brexit. Obviously, there were loads of immigration, freedom of movement between the UK and Europe went, and then COVID hit. So a lot of this sort of travel overseas was put on ice for a while, and the penny about restrictions on travelling for work into and out of Europe kind of got delayed, and it's only just now that the penny is beginning to drop on the immigration implications. And when those immigration requirements go wrong and they're not met, as you can imagine, these can have serious financial, reputational, and most often practical consequences. So employers of record can be of use from an immigration perspective in remote working situations. As Miriam was saying, an organisation might have an employee who wants to work in another country, and that employer has no need or intention to set up an entity there, or the employer might be expanding into new territories and is the one that is wanting to send an employee to work in a specific country, but it's not yet sure whether it wants to go to the trouble of setting up an entity in that country. And so they're just testing the water in that new territory initially. So in either scenario, an employer of record could be the answer, as Miriam has said, but in both cases, it might just be correct that the employee is going back to their country of nationality, or going to a country where they happen to already have the right to work there. So if that's the case, when you're talking about employers of record, you're not going to need to worry about this. One thing you're not going to need to worry about is the immigration aspects. But as we all know, it's not always that simple, and immigration issues have a habit of putting a spanner in the works at inconvenient times. In those sorts of cases where the employee doesn't already have the right to work for immigration purposes in the country they're going to, I would be quite wary of employers of record who are offering to be all things to all employers. And the reason for this is that if an employee doesn't already have permission to work in the country they're going to be working from, you and the employee can't simply assume that because they are only working for an entity in another country, in other words, overseas remote working, you can't just assume that they don't need permission to work in the country where they're going to be based. even if, and this is something that comes up a lot, they have done that in the past, or they know people who've done it in the past, or to all intents and purposes, they've been getting away with doing that, remote working overseas on a tourist visa, a visitor visa in the past, and haven't had any issues. From a business perspective, it's just not really worth the risk. It's just not worth taking that risk once you know about it. With immigration situations, people can fly under the radar for quite a long time, and then when it goes wrong, it goes horribly wrong. The sorts of penalties we're talking about are, as you can imagine, financial penalties, but people being turned back on entry to a particular country, getting negative immigration records, or in really severe situations being sort of detained, which is obviously highly stressful and unpleasant. So if an employee needs a work visa in a particular country, when you're dealing with a PEO situation, employer of record situation, the challenge is that you need to bear in mind that most visa routes require the employee to obtain their work visa through an entity established in that country. So on the face of it, you're thinking, oh, well, maybe that could be the employer record. But the problem is that many of these immigration systems require that it's not just an entity who is going to be the employer in that country, but it needs to be an entity that the employee is actually working for or being managed by. In other words, the employee must be filling a genuine role for that employing entity in the host country. The UK in particular has very strict rules around the fact that the sponsor of a work visa must be the entity that is responsible for the employee's day-to-day activities. So in most situations, an employer of record entity in that employee's host country is not going to be able to sponsor that employee for visa or immigration purposes. So that means you're then going to need to look at whether the host country offers some sort of visa which doesn't require an employer sponsor. So there are a few countries where these are available, but unfortunately it's just not the norm. So France and Germany have a form of freelance visa which is open to workers in certain sectors, and they don't require a local employer. So that type of visa might be suitable if you're engaging with an employer of record. In other cases, there are visas for self-employed workers. In practice, they're generally linked to starting up a business and require proof of that person doing work locally, which is the case in the Netherlands. So that's not going to really fit with the employer of record model that we're talking about. And then there are other countries who operate work visa routes that don't require an employer sponsor, but in practice they tend to set quite high thresholds or very specific criteria that can be more difficult to meet. So, for example, in Australia, there's a skilled independent visa which is open to workers who are under the age of 45 and have particular sought after skills in certain occupations. But that route is limited because it's geared towards applicants with who have existing links to Australia, and the big showstopper for me is that it can take up to 3 years to process. Other examples in other countries for the visas which don't require a local host employer is the UK has something called the Global Talent Visa, but that's quite restrictive because it's designed for leaders or potential leaders in academia, arts, digital technology, and they will only qualify for that visa if they have been got an endorsement from a specific industry body. So that's probably not going to fit within the employer of record model that we're talking about. And similarly, there's a UK innovator visa that's just become more accessible because they're removing the requirement to invest £50,000 in a business. But again, that requires the setting up of a business in the UK, which is just not really kind of going to fit with the purpose, the real reason why you're looking to use an employer record in the first place. There are some other alternatives. So, for example, there are increasing number of countries which offer what are commonly referred to as digital nomad visas. And these often have very enticing locations such as the Bahamas and the Cayman Islands, but closer to home, Portugal, Romania, Spain, Croatia, Cyprus, Greece, and also Dubai offer this type of visa, and that could work in an employer of record situation. But as I'm listing off all these countries, you can see that it follows that each country has its own rules, so a fair amount of work is going to have to be done to establish whether or not that route is suitable, let alone, are the countries where these visas are available, does that fit within your business plan or the countries the individual wants to remotely work from. And so those types of visa can work in this situation. And the advantage is that there isn't the requirement for a sponsoring employer in that particular host country, so you wouldn't need to worry about the absence of a real employer who is actively managing their work, which is obviously often the risk with an employer of record situation. But the difficulty with these types of visas is that there is also often a ban on the individual taking local employment. So that would, in principle, prevent them from being, on the face of it, employed by an employer of record in that country. So again, another challenge as to why these various visa options might not work. Digital nomad visas tend to be offered for a very limited period only, so they're not a long-term solution. And they usually have quite limited options to transition into a more permanent visa route. And the other issue, which is not yet fully emerged, is that some countries, having set up digital nomad visa routes during the pandemic, are now sort of rethinking those routes because they're not convinced that actually it has the economic benefits that they thought it would. So if you need to use these visa routes, you shouldn't be banking on them as part of a kind of long-term strategy. So from an immigration perspective, using an employer of record, it either won't be an issue at all because the employee already has the right to work where they're going, fine. But if you're sending in workers, employees into countries where they do need a work visa, using employer of record or a PEO by itself is generally not going to be the answer. Someone's going to have to do some additional work and around finding out the right type of visa and then actually putting that in place. So that's immigration. And then related to this, the whole issue around cross-border employment arrangements is the lesser known issue of restricted labour leasing. And this is particularly problematic and causes issues in Europe. And that's because it can lead, most important thing is that it can lead to fairly hefty civil or even criminal liabilities. In some cases, the maximum fines are around 200,000 euros, so certainly not insignificant. So what is labour leasing? It's the practice whereby an individual is employed by an entity operating in one jurisdiction, but in practice they work for the economic benefit of, or they're recharged to another entity in the same or another jurisdiction, and sometimes that can be within or without outside a group of companies. So that's typically how it works. And this essentially describes the employer of record structure we're talking about. Somebody works for one entity and they're assigned or leased or lent or repurposed to another business. And the challenge is that labour leasing is actually prohibited or at best highly regulated in most European jurisdictions. And the rationale for this is that though local labour authorities in those countries are keen to protect employees' rights, ensure that the employees know who their real employer is, in some cases, the employee could end up asserting some sort of co-employment situation which would maximise their benefits or termination package. Essentially, they kind of have the option of suing both or the cherry picking the best employer from their perspective. And then in other jurisdictions, even though they don't necessarily refer to it as restricted labour leasing, those types of arrangement are regulated on a similar basis, but it's referred to it's generally referred to as hidden employment, which is also regulated and restricted. And so when labour lease in the countries where labour leasing is restricted, there can be certain exceptions, which mean if conditions are put in place and adhered to, then that labour leasing is permitted, albeit sort of still heavily regulated. So that could be, for example, where the leasing takes place within a group of companies, but by definition, that's not going to help us in the employer of record scenario because we're not talking about intra-group transfers. In some cases, in order to be able to go ahead with the labour leasing, you need to get local labour inspectorate approvals and notifications. In some cases, the requirement is for the arrangement to be set out in a specifically worded service agreement. But then in other cases, the leasing might be permitted, but it's only permitted for a limited time. So usually around the time limits tend to be around 18 months or 2 years. So again, this employer of record arrangement is not going to be a long-term solution if that's what you're really looking for. So these restrictions are applied with on varying degrees across Europe, but it's France, Spain, Poland, Belgium, and Czech Republic, and Italy, and also Germany. They're particularly problematic from a labour leasing perspective, and so in those countries it's either prohibited altogether or permitted, providing you meet certain conditions, and then it's closely regulated. So it's unfortunately another one of those things you have to add to the list of issues where you would get specialist legal advice to navigate the rules in those countries. And of course, the rules are slightly different in each jurisdiction. So yeah, I mean, to sum up, if you're thinking of using an employer of record in Europe, one of your first questions would be whether that arrangement is compliant from a local labour leasing restriction perspective, and then, as I said before, factoring in the immigration compliance issues as well. That's all for me from now. Patrick, am I handing over to you now?
Yeah, thanks, Annabel. I'll say a few words about the tax position. So the main tax benefit for using a PEO or employer of record would be the payroll taxes. So typically they would take responsibility for the payroll taxes, operating the payroll, the administration of it, and paying the tax over to the tax authorities. One point to think about, though, is if that is your main reason for using a PEO, there's an initial question of, well, actually, are there any payroll taxes, social security to pay? For example, if you might just actually be sending someone from the home country to the other country for a limited period, in which case, in certain circumstances, they may have no tax or social security to pay in that other country. Typically for tax, that's a period of less than 6 months in most countries. There's no tax to pay. And even if it's an individual who is a national in that relevant country and you're employing long-term in a country you don't have a presence in, it won't necessarily be withholding tax akin to PAYE in the UK in the other countries. Some countries don't have tax withholding, and other countries, even where they do, there isn't an obligation on an employer if they don't have a place of business in that country. So, for example, UK is like that. So if a US employer were employing someone in the UK and didn't have any place of business there, they could just let the individual employee pay their own taxes under self-assessment, and they don't necessarily have to operate payroll or engage a PEO to operate payroll. Although, having said that, some employees, because they're used to tax withholding in their country, still expect that to happen. So that can sometimes be a reason for for having a PEO operating payroll because the employee doesn't want to pay their taxes themselves under self-assessment. So that's just a point worth thinking about. And actually, it's probably a kind of appropriate point to answer one of the questions which has come up, which is we've got a Greek national working in the UK on a UK contract of settled status, but she wants to spend more time in her home country of Greece, no visa issues, but at what point would she become liable for social security payments in Greece? If less than 183 days, then no tax issues. And at what point might we need to consider an entity or employer of record? So that's an example where someone is temporarily going to another country, in this case Greece, don't have a place of business in Greece. As per the question, you wouldn't expect any tax liability if it's less than 183 days in Greece. And the social security position within the EU and UK is still included within these rules. If someone is being posted for not more than 2 years, you can actually apply for something called an A1 certificate in the UK to get confirmation that they just remain on UK national insurance, and then it wouldn't be Greek national social security in that example. So within the EU, you have a system where typically there should only be social security in one country if someone is moving between countries or working in different countries. So that would be an example of it. If the person isn't there for more than 6 months, potentially you don't need a PEO because there is no tax or social security in Greece to be dealt with. One of the tax points that a PEO doesn't really help, it doesn't make worse, but it doesn't really help is the corporate tax position. So something you should be considering where you've got an employee or employees working in another country where you haven't typically operated is whether they are giving you a corporate tax presence in that country. So will you actually have to pay corporation tax in that country on some of the business's profits? And that can be based on a couple of factors, and the term used is a permanent establishment. So if you have a permanent establishment in the other country, that means you have to pay tax in that country, corporate tax on the profits of that permanent establishment. And the most typical example of a permanent establishment is what we would refer to as a branch. So where you've set up a proper office in that country, you've got employees working there. Clearly, you've got a branch and you've got a tax presence. But you can also have a permanent establishment in less obvious situations. In terms of the different things which can trigger a permanent establishment, one is having any physical place of business. So, for example, if your employee in the other country starts working from an office, so rather than just work from home, they work from an office, say a WeWork office, but they present it as an office of the business. So, for example, in business materials or on a business card or something, it's suggesting that's your business's office. That would be a permanent establishment and could trigger corporate tax liability in that country. So you have to be careful that they're not holding out any particular physical address as an address of the business. Or also, even if there is no physical place of business, if they're entering into contracts on behalf of the business, or in some cases, if they're taking high-level management decisions in the other country, that in itself can also trigger a permanent establishment and a corporate tax liability. And a key point to remember in the context of a PEO or employer of record is they are unlikely to remove that risk. Although they wouldn't be your employees if the employer of record is employing them, it's likely that most tax authorities would look through that for the permanent establishment test. And so, for example, if they're entering into contracts, you've got a salesperson in another country and they're selling and they're contracting the sales, even though they're not technically your employee, the the tax authority is likely to look at that they're entering into contracts on your behalf and they're giving you a permanent establishment there. So although you will see some PEOs marketing themselves as mitigating that corporate tax risk, I wouldn't take that at face value. As I say, I would review it as if they were your employees. Would you then have a permanent establishment based on the usual test of whether there is a physical office or they're entering into contracts on your behalf or taking high-level management decisions? In terms of a couple of other tax-related points just to watch, or tax and benefits-related points, one which I've seen a few times come up, it relates to employee share options and the fact that if you are using an employer of record, it does complicate it if you're looking to grant a share option to the relevant employees. Because they're not your employees legally, for example, you might have an employee share option scheme which relates to employees of your group, but they wouldn't be an employee of your group. So they don't fit easily within that option scheme. And there are often regulatory exemptions, for example, securities law exemptions from having to offer a prospectus for offering shares, which might not apply if you're granting an option to a non-employee. So it complicates that side of things. It also can complicate the tax administration, because when the option is exercised, potentially that's the PEO that's having to deal with the tax on that. But are they aware of that? Are they willing to do it? Because not all PEOs are familiar with that, and it can get quite complicated. And then as an added point to that, some countries, and the UK is a good example, have tax beneficial types of options, but they might not be available where you've used an employer of record. So if you look at the UK, for example, we have a type of option called an EMI option, which is very tax favourable, but is only available for employees of the relevant group that is granting the option and offering the shares. So wouldn't be available in an employer of record situation where actually it's the PEO employer of record that's employed the individual. And some other countries have similar tax benefits on options which may not be available. And just a final other example of related to that, where the fact they're not your employees could have some adverse effects on tax benefits. So say, for example, in the UK, we have a benefit called research and development relief. So companies can get tax relief on their corporation tax, but the level of relief you get is significantly higher for expenditure related to your employees as compared to expenditure related to your non-employee staff, which would be the case for employees through an employer of record. And so the level of relief available would be lower where a PEO is used. And so there could be equivalents in other countries, depending on their tax laws, where you just may be losing out on a relief because they're not actually your employee. Those were the main tax points I was going to make. I'm back to you, Miriam.
Thanks, Patrick. So just for the remaining part of the webinar, I'm going to talk about some of the employment law issues that you need to be thinking about, and also focus on some more commercial points that you need to bear in mind. So just on the employment side of things, firstly, as I mentioned, in our experience, very few clients use the PEO co-employment model outside the US because it requires both the PEO and the end user client to separately employ the employee. And in most cases, obviously, the end user client doesn't want to have a direct employment relationship with the employee. So again, I'm really going to focus what I'm talking about now on that employer of record sole employment model. So as a first issue, from a practical perspective, many of the employers of record require that you use their own standard form contracts of employment, which they've developed for each different market. They do generally allow some tweaking of the contract, but I've seen contracts that say that will be a limited number of changes. Some of the contracts that I've seen can sometimes be quite basic and they won't necessarily work for the nature of your business. So you may need to try to get the employer of record to agree to make fairly substantial changes to their standard form templates, and they can often be quite reluctant to do that if this means that the end document differs substantially from the starting point template. A really big area of challenge and concern in the employer of record sole employment arrangement is the fact that it creates very significant challenges when it comes to the usual contractual mechanisms that you would put in place to protect your business, namely provisions relating to confidential information, intellectual property, and post-termination restrictions. And this is because when you're using an employer of record arrangement, there won't normally be a direct contractual relationship between you and the employee, because the employment contract is between the employee and the employer of record. So this means that you're not going to have any direct contractual obligations as between you and the employee to protect your confidential information, intellectual property, and other legitimate business interests through the imposition of post-termination restrictive covenants. Now, obviously, many of the employer of records do include those types of provisions in their standard templates of employment, but certainly from a UK employment law perspective, it remains untested whether a UK court would enforce provisions in an employment contract between an employer of record and the employee, where the confidential information and legitimate business interests that are being protected are those of the end user client, who's obviously not a party to the employment contract, which is between the employer of record and the employee. There's therefore no guarantee that any confidentiality and IP provisions or post-termination restrictions in the employment contract with the employer of record will actually protect your business as the end user client. However, in reality, it will be your confidential information, clients and employees who the employee will get to know through providing the services, not that of the employer of record. And that's particularly risky where you're considering engaging a fairly senior person through an employer of record. Now, in the UK, we think that with the right drafting, it should be possible to address that issue by getting the employee to enter into a separate agreement where the employee directly contracts with and enters into confidentiality and IP provisions and post-termination restrictions directly with the end user client. However, this is likely to be far less straightforward in other countries. And we certainly know that in a number of countries, particularly in Europe, you have to pay for restrictive covenants. And also the existence of this type of side agreement in itself, I think, will increase the risk of co-employment or employee leasing issues and claims. And again, the issue here is you're going to have to look at this on a case-by-case basis. And in virtually all markets around the world, this is really a new and untested area. There's then the issue of the extent of the control that you can have over employees who are engaged through an employer of record. Most of the employer of record terms and conditions that we have seen state that the employer of record will be responsible for managing the employees, and this is presumably to try to reduce the risk of successful co-employment claims and to reinforce the picture that the employer of record is the genuine employer. However, some of the terms that we've seen then go on to state that you as the end user client will be responsible for providing day-to-day supervision of the employees, which begs the question of how management and supervision actually differ in practice. What is also an issue is that none of the employer of record terms and conditions that I have seen actually go into detail about what managing employees actually means in practice. So, for example, there'll rarely be details about who handles matters such as employee complaints or grievances. And if the supervisory aspect of your role as an end user client is supposed to be something less than the managerial role of the employer of record, then it follows that it should be the employer of record who will be dealing with complaints and grievances. But they will rarely have the knowledge of your business to be able to effectively consider those types of complaints. And if they delegate it down to the end user client, that is again likely to increase the risk of a co-employment exposure. There's then the question of how you fairly terminate at the end of the arrangement. In the UK, I think that it should be possible for an employer of record to rely on one of the potentially fair reasons for terminating, either redundancy or possibly some other substantial reason. But again, the position may well be complex in other countries, and that would require investigation. And the challenge is that pretty much all terms and conditions with employers of record will have an indemnity where the employer of record will pass on liability for termination costs and any associated termination liabilities to the end user client. So it's particularly important that you are clear on your financial and legal exposure on both the entry and exit of this arrangement. So I think, as will probably be apparent from my comments, the biggest challenge overall with an employer of record arrangement from an employment law perspective is that we just don't know what we don't know at the moment. It's very much a new and developing area, and we just don't have the certainty as to how these arrangements will be viewed and assessed by the relevant local courts and tribunals, which brings with it, of course, a huge degree of risk. So I said I mentioned some of the commercial points, just that I think you need to bear in mind. Firstly, and this is the money point, PEO and employer of record services are invariably a pretty expensive way of engaging talent. Most of them charge on a cost plus basis, not all of them, but a lot of them do. What that means is they charge you for the costs of employing the employee, and then they'll charge you an additional fee to cover their services. And these fees obviously vary from provider to provider, but it's not uncommon for them to charge in the region of 20 to 40% of the costs of engaging the employee. So that is a substantial additional cost. The other thing you need to do is take a really close look at the terms of your contract with the PEO or employer of record provider, because they do have some stingers. One key point to note is that, and this is obviously really relevant given what we've talked about, PEO and employer of record standard contractual terms invariably don't give any guarantees that their model will address or solve any of the employment tax and immigration risks that we've just talked about. One of the terms and conditions that we've seen includes the clause, services will be delivered at a standard no less than the standard in the industry. That doesn't really give you any general comfort if the entire industry isn't really addressing those risks at all. Effectively, what this seems to be saying is we aren't doing this any worse or any greater risk than anybody else, but that's hardly particularly reassuring. So one point to look at. There's also quite a significant degree of inequity in the protections and indemnifications that the providers will want from you as the end user client as compared to what they're prepared to offer you in return. It's very common for PEOs and employers of record to require you to indemnify them in the event of any claims being brought against them as a result of any acts or omissions by you or your employees. However, very frequently, the provider standard terms don't include any reciprocal indemnification of the end user client in the event of claims being brought by an employee as a result of actions by the PEO employer of record or its staff. And this obviously brings with it particular risk in the case of employers of record services, given that many of their terms and conditions stipulate that the employer of record must manage and in many cases terminate the employee. So they'll be in that position of control, but you will have no recourse against them if they do it wrong. On a similar vein, we've seen contractual terms which prohibit you as the end user client from soliciting the employees of PEOs and employers of record, but then the terms don't contain any reciprocal restriction on the employer of record soliciting the individuals that they employed on your behalf, which means they could, in theory, poach your indirectly, I guess, engaged staff on behalf of one of your competitors, and you'd have no recourse against them. There's then also the issue of the extent to which the service provider is required to assist in the event that claims are brought against either the employer of record or the end user client by an employee who has been engaged by an employer of record on their behalf. A number of the contractual terms that we've seen don't contain any obligation on the part of the employer of record to either defend such claims or to assist the end user client in litigation if a claim is brought against the end user. And in many cases, the employer of record will require the end user to indemnify them for all costs arising from termination or any associated litigation. Now, those costs could be significantly higher if the employer of record is sued and just decides not to defend the claim, but they can just rely on the indemnity and get all the costs back from you. Similarly, if a claim is brought against you as an end user client, it's very likely you're going to need some kind of input from the employer of record, whether that be the provision of documents or even a provision of witness evidence. We have seen one set of employer of record contractual terms where the employer of record states that they will provide support in the event of legal proceedings being issued if requested, but the terms then go on to state that the fee for providing that support will be agreed at the relevant time. Now, obviously, at that point, the employer of records pretty much got you over a barrel because they know that you will need their assistance with the litigation, which puts you in a very weak position when trying to negotiate the amount of that assistance fee. So if at all possible, you should try to getting some certainty at the outset, firstly as to the extent of the support that the employer of record would provide in the event of litigation, and also how much they would charge for that support. So I guess overall, therefore, it's really important that before you sign up to anything, you look very, very carefully at those terms and conditions. Try to identify those types of inequitable obligations or any omissions and see if you can renegotiate them. So wrapping up, I guess, where does this all leave you as a company considering whether or not to use an employer of record or a PO? We've obviously, because we're lawyers, focused on some of the legal risks and challenges that you need to be thinking about when reaching that decision. But it is undoubtedly still the case that particularly the employer of record model does offer a solution for a problem. We've had discussions with a number of clients who have opted to use an employer of record service, even understanding the risks, because the business simply needs an immediate solution to hiring talent in a specific market, or sees it as the least challenging route, at least in the short term, to testing out a new market. And ultimately what it seems to me this comes down to is ensuring that you go into the arrangement with your eyes wide open, be that by having gone the extra mile in terms of researching the legal position in the country in which you're going into or considering operating, or just understanding that there are risks associated with the model, but accepting that the commercial need to engage talent in that location quickly takes priority to those risks. So hopefully this talk's given you a flavour of some of the issues that you ought to be thinking about. You'll appreciate, as this is very much a developing area, we haven't got all the answers, but we're trying to kind of work our way through as this, as time progresses. And we have got a few questions, and we'll do our best to answer some of them. Some of them are definitely egghead type, head-scratching questions. So let's see what we've got. Annabel, is any there that you think you can put your mind to?
Yes. So one of the first questions was, who would take liability for reviewing a right to work document? Would it be the employer or the employer of record? And certainly, if you're looking at that from a UK perspective, and the UK being the country I would say has the most stringent and prescriptive right to work requirements, if you were talking about an employer of record in the UK, as long as, I know we've talked about our employers of records really the employer because they don't manage the employee, but in this situation, assuming there is a contract of employment between the employee and the employer of record, and in fact that employer of record is the only entity that could be pinned, the only entity that could be said to be an employer, it would be that employer of record that does the right to work check, because in this arrangement we're assuming that the real employer is not even in the UK, so it would have to be an entity, the employer in the UK, even if there's questions about who is the real employer. And on that note, I mean, it's a good question in the sense that the Home Office are quite prescriptive about who carries out the right to work check, and the rule around that is that it has to be done by the employer, not a third party which is engaged, for example, a recruitment organisation or a checking, a background checking organisation, that sort of third party. But I think in this situation, it would actually have to be the employer of record.
Thanks. We've got a question here, which is where liability is dual for a PO, because obviously talking about that dual employment PO model, who would take liability where an employer of record is engaged? And I guess that's the million-dollar question, because on the face of it, it should be the employer of record. They're the employer. And I guess if we were looking at this from a UK perspective, again, I think that the starting point would be the employer of record. And the UK doesn't really have concepts of co-employment and dual employment in the way that other countries do. The challenge is that, and this is what I was alluding to in my talk, that the model brings with it a risk that in certain countries, employees could claim co-employment, in which case, presumably, they would bring claims against both the employer of record and the end user client. And therein lies the problem. But ultimately, this is one of those questions which will vary from country to country, and where you'd need to get the kind of specific advice if you wanted to bottom out the risk there. Annabel, was there another one that you were going to go for?
Yeah, there's another question which was actually about unrestricted labour leasing. How are employers of record able to offer their service in these countries if it's essentially illegal? Do they get prosecuted? Which is a very good question. So it will depend on the country. So in some countries it may be possible subject to those conditions. In the countries where it is absolutely prohibited, then yes, there is a risk. And I mean, we've seen cases of clients sort of setting up labour leasing arrangements within groups, sort of, or in situations which don't involve an employer of record, and we know how easily that happens. And clients talk to us about it, and they honestly had no idea it was an issue until it was raised. So I'm fairly sure that this sort of breaches of labour leasing is happening all the time, because particularly organisations outside Europe don't necessarily know about it. And it's not necessarily the case that these organisations are going to be prosecuted, because it just may not come onto the radar of the local labour authorities. And if it does, then it's not necessarily criminal prosecution. It's probably more likely to be a sort of civil penalty situation. But yes, if people are breaching these, then they're at risk of specific sanctions.
It's just a question that's just come in, which is kind of both tax and employment related. So a couple of our senior team are located in the UK and have been employed by an employer of record for over a year now. This is one for Patrick and then one for me. Would that be a reason for us to be under a tax risk? And also, would a side NDA be legally binding in the UK? I'll take the last question, then I'll pass over to Patrick. I do think that there are ways of structuring this so that a side NDA would be legally binding in the UK. You need to think a bit about consideration, but we think there's wordsmithing around that you can do it. I think it's probably more problematic in other countries, but I think the UK certainly takes a more straightforward approach to that than some other markets. But again, it's a matter of the way that you draft it. Patrick, tax risk side, which I guess is maybe one about permanent establishment.
Yeah, so presumably this is getting at corporate tax risks.
Yeah.
And presumably, so it's an employer of record of 2 senior team members being employed in the UK for over a year. It comes back to what I was saying earlier, that the fact that there's an employer of record there doesn't take away the risk. The 2 key points you need to be considering: do you have a physical place of business in the UK? If the 2 individuals work from home, then that would seem unlikely. Or do they enter into contracts on your behalf? And that's definitely something you should avoid them doing in the UK, because that will potentially give you a UK presence. In terms of them being senior team members, within the UK, this can differ slightly in different countries. That's not generally an issue in itself, as long as they're not essentially managing the business at the top level, which is kind of board level, really. That shouldn't be an issue, that they are senior. There is an element of practicality to it, in that what I've just told you is the technical position, but as you get more employees in a country and they stay there for longer, the risk of the tax authorities, so the UK revenue in this case, taking notice just tends to go up. And so the practical risk goes up. The more people you have, the more senior they are and the longer they are in a country. But just the fact that there are 2 senior people in the UK for over a year wouldn't in itself mean you've got a corporate tax presence if you haven't triggered those points about not entering into contracts, not having a physical place of business.
Thanks, Patrick. I think we've probably got time for one last one, which is a doozy. On a general basis, and I'm not promising we've got the answer for this because we certainly don't, but we'll try to give you some thoughts. How would you guys advise an organisation who is about to engage a PEO for multi-jurisdictional engagements of employees about mitigating or minimising local co-employment risks, noting that Yabu sucks, the PEOs invariably won't provide an indemnity for such an exposure to future risk, which goes to my point about what they won't give you in terms of indemnification. It's a really challenging one, and I'll be honest with you, it's one that we're still working through, and it will vary from country to country. My couple of thoughts, co-employment is often, focusing around the extent to which they've got contact with you and which key employment decisions and management, who's responsible for them. In an ideal world, you will be limiting the extent to which they have meaningful management engagement between, you and the guys that you're engaging through PEOs. I just don't really see that going to work in practice, and it's a real challenge. Because reality is that you will have the kind of main day-to-day involvement. Apart from that, keep them short. My view is that overall, as I said, the employer of record service is a valuable one in the sense that it solves a problem, but then creates other problems. But I really think it's best used for short-term engagements. And I think, rule of thumb, the shorter the engagement, probably the lower the risk of co-employment claims. But other than that, I think it's going to be one where we have to see how kind of case law changes around on this over the years, because as I said, this is still such a developing area of law, and it's going to vary from country to country. So I hope that you've all found that useful. Annabel, Patrick, thanks so much for taking time to speak to the audience today. You can find us on our website if you've got any questions, but thank you so much for taking part, and thank you very much for all of your questions. They're very much appreciated. And have a good rest of the day, everybody.